Welcome back, dear students. In the last session, we had discussed about the concept of culpable homicide, and also we discussed section 299 of the Indian Penal Code. And in this session, we are going to discuss about the intention part in culpable homicide. As I discussed in the last session, this is going to be the determining factor in every cognizance under section 299 of the Indian Penal Code, right. So, the first thing is, if you will take or let me say the common context of intention under Indian Penal Code, which says that there must be a intention, or there must be a pre-arranged meeting, or there is a premeditation, right. All these are required in order to conclude that there is an intention, there is a conspiracy, right. There is a all these it shows that there must be an intention, right. But see, that is the importance under section 299. In order to consider whether there is an intention or not, all these element is not required, right. There is a conspiracy, premeditation, or there is a gathering, right. All these things are not required. So, what is required is that there must be an act, right, and that act, in consequence of his act, which is likely to cause the death of the person, is sufficient to constitute the intention of the persons. So, as I said, so it is a different species of intention. I would say that it is, we can in certain instances under section 299, we can call it as a constructive intention, right. A person does not have an intention per se, but his act would likely to cause the death of the other person. In such cases, what we can presume, or we can say that there is a clear intention under for the particular act, right. And it is a natural theory that suppose I am doing some act, right. When I am doing some act, right, I am expecting certain consequences, right. So, the same theory has been applied to section 299 of the Indian Penal Code. So, what is the theory, right? When I am doing certain thing, I am expecting certain consequences, right. So, under 299, which says that, so that is what, go to section 299, which simply says that there must be an intention, there must be a bodily injury which is likely to cause the death of the person, and the third one is knowledge, that is very important, which simply says that I have a knowledge that my act would cause the death of the other person, right. So, this is that is what I said, the common concept of intention which is applied in this particular case in a very restrictive way. There is no pre-planning is required, right. So, even an act coupled with the death of the other person, right, that is quite sufficient to constitute what the intention under section 299. This is very, very important, right. See, there is one case, Muhammad Arif versus State of Uttaranchal, right. What did the court, the honorable Supreme Court held that, what suppose a particular person is doing certain act, right, and when he is doing certain acts, he is expecting the death of the other person. When I am doing certain act, I am expecting the death of the other person, right. That means I am having a higher degree, what is high degree of knowledge or high degree of intention to commit the offence, right. And again further the court said that too, right. I have a there is likely that my act would cause the death of the other person, right. That means because in consequence of my act, right, I am expecting a dangerous injury, expects a dangerous injury to the in consequence of the act, right. And the third one is there is a knowledge. What is the knowledge? Knowledge that my act would cause the death of the other person, right. So, all the three conditions, three situations, let me say three situations, and death happens subsequently in consequence of my act, then the court said that simply you can invoke section 299. So, again the court said that I am expecting death of the other person, go to section 299. Second one is a dangerous bodily injury, I am inflicting a dangerous bodily injury to the other person, expecting what or likely to cause such bodily injury to the death of such a person, right. and I have a knowledge that this person is going to die soon, right, and death ensues in all the 3 cases, then what it simply says that then section 299 can be invoked. It was held in Muhammad Arif versus State of Uttaranchal. In another case, State of Andhra Pradesh versus Pannaya, right, this is very important. The court is talking about the 3 degrees of intention. It's very important, right. So it is saying that, and what the court is saying that instead of blindly invoking section 299, it talks about 3 levels how 299 and its punishment can be invoked. Let me say the court first simply says that if if there is the first degree of intention, right, the culpable homicide, or let me say the lowest degree of intention, right, then what will be the maximum punishment? It is simply says that the court is competent to give a fine also, right, the court is competent to impose fine, or it can give a punishment up to 10 years. See, listen, I am again repeating. In this Andhra Pradesh, State of Andhra Pradesh versus in Pannaya, the Honorable Supreme Court said that in a culpable homicide case, right, it simply says that if you have a very less intention to kill the other person, you doesn't have an intention at all, right, but somehow it happened, in such a cases, what is the punishment under this particular case? It says that the court can impose a fine up to fine or 10 years of imprisonment. What is the maximum fine which the court can impose? It is not mentioned. It is up to the prerogative of the court, discretion of the court, right. It imposes, but what is the point, what is the catching word is that the court can impose fine and then the court matter can be adjudicated. Second one, the second degree of intention, that is very important. The second degree of intention simply says that it can impose the punishment up to 10 years, right, the second degree of intention, right, or it can impose life imprisonment also, right, or again subsequently it is added if the court feels that, or it appears to the court that fine has to be added, then the court can add the fine also. So, first intention, second intention, first is considered as the lowest degree, right, and the second is which is relatively higher than the first one. The court say that the court can impose 10 years of imprisonment or life imprisonment, or the court can add fine also. And the third, let me say the third degree of intention, that means the highest degree of intention, that means a person is very particular, right, but his act means only to cause the death of the other person. In such a cases, the law says that the death punishment can be imposed, right. See, I am talking about the intention, right. In order to impose or invoke section 299, there are 3 layers of intention, right. So, the last part says that if a person is imposing causing the death of the other person, right, he causes the death of the other person, then, and it is very clear a person is having a high intention. In such a cases, the court will presume that the person is having a high intention. In such a cases, death penalty or 10 years of rigorous imprisonment, or with both, or with fine, or the court can impose fine also, right. So, this is what was held in State of Andhra Pradesh versus Andhra Pradesh versus Pannaya's case, right. In another difficult circumstance, let me say one illustration, right. There is a particular one person killed the other person, right, and there is no it is a very difficult case to identify or to figure out the intention of the other person, right. In such a cases, what will be the ratio, right, this is very important, right. If there is a case of it's a case of let me say murder or culpable homicide, we do not know which is the correct one, but the thing is, it is very difficult to identify the intention of the other person. In such a cases, it's what will be the ratio, it is very important. So, in this particular case, if situation this comes, right, the court has to apply in Woolen's directions. This is a very famous case, R versus Woolen's, right. In that particular case, what the court has applied that the connection between the primary cause of the death, right, and the death should not be too remote. That means there must be a nexus between the death and the act done. The death and the act, what it should be so close, right, and it shall not be too remote, and this ratio has been adopted or has been borrowed by the Indian Supreme Court in Moti Singh versus State of Uttar Pradesh, right. So, that is what is very important, right, in order to invoke what the intention part, or in order to consider the intention part, right. So, what is important here is that what there must be a close connection between the act as well as the death of the person. The death is shall not be too remote, right. Then only you can say that there must be a nexus between the act and the death, thereby automatically the concept of intention will come into play. Then only you can say that yes, there is an intention from the part of the other person. See, if you ask about the intention, we know that the question of intention is always a question of fact. Direct proof of intention is, it is very difficult to get in criminal cases. It is very difficult, right. So, how you will come to a conclusion that there is an intention if there is a pre-planning, the contact, motive, subsequent act, previous act, which is very relevant under the Indian Evidence Act also, right. So, if you consider the subsequent act, previous act, right, then motive, preparation, conspiracy, all these elements constitute intention, right. So, here that is what I said, the question of intention, it is always a question of fact. In another case, in the Honorable Supreme Court held in Chatkhan versus State of Haryana, there the Supreme Court held that when injuries are inflicted on the vital parts of the human body, right, let us say in lungs, hearts or in any other vital parts of the human body, then it leads to an irresistible inference that the person is having a higher degree of intention, that I said the third degree of intention, to commit or to kill the person, right. There we can presume or we can take an inference that this person is having an intention to kill the other person. So, we already discussed how the intention should be figured out in a case where section 299 of the Indian Penal Code has been invoked, right. So, remember there are different kinds of intentions. Let me use the word different degrees of intention. On the basis of degrees of intention, we will come to a conclusion whether it is a culpable homicide or whether it is a murder, right. So, I hope this discussion would help you in identifying a particular act, whether it fit into section 299 or murder 300. So, in the next section we are going to discuss about the last part, that is knowledge, how the knowledge is vital, how the knowledge is detrimental in invoking section 299 of the Indian Penal Code.